The opinions of the court in 5 cases will be announced by Justice White.
Opinions have been filed with the clerk explaining the actions taken in the following 5 cases. First, in 88-1000 New York against Harris, we reversed the decision of the New York Court of Appeals by a 5-4 vote. Justice Marshall, joined by Justices Brennan, Blackmun, and Stevens, has filed a dissenting opinion. Second, we affirm unanimously the judgment of the Court of Appeals for the Ninth Circuit in 88-1725 Venegas against Mitchell. Third, we affirm the judgment of the Minnesota Supreme Court in Minnesota against Olson. Justices Stevens and Kennedy have filed concurring opinions, and the Chief Justice and Justice Blackmun have noted their dissent. Fourth, in Osborne against Ohio, 88-59-86, we reversed the judgment of the Ohio Supreme Court by a 6-3 vote. Justice Blackmun has filed a concurring opinion. Justice Brennan has filed a dissenting opinion. He is joined by Justices Marshall and Stevens. Fifth, by a 5-4 vote, we affirm in part and reverse in part the judgment of the Court of Appeals for the Eighth Circuit in Missouri against Jenkins, number 88-1150. Justice Kennedy has filed an opinion concurring in part and concurring in the judgment in which the Chief Justice and Justices O'Connor and Scalia have joined.
The case of Missouri versus Jenkins is of sufficient gravity that it seems appropriate for me to read from portions of the concurring opinion that has been filed today. The case involves a school desegregation plan adopted by a United States District Court in Kansas City, Missouri. As part of a remedial plan, the local school districts and the plaintiffs together proposed and the district court ordered expensive improvements to the local school system. By the time of the order at issue here, the cost of the plan had risen to approximately $500 million, far exceeding local budgets or revenues. The district court then decided that it would fund the plan by imposing a property tax directly on local citizens. The court is unanimous in its holding today that the Court of Appeals judgment affirming the direct imposition of taxes by the district court must be reversed. But this separate opinion is necessary because the majority has gone on, in statements not necessary to the resolution of this case, to approve a system whereby the local school district would set the rate of taxation and the federal court would then allow the school district to impose the tax, even though it is in direct violation of Missouri law, under which the voters retain the right to approve tax increases through direct vote. Absent a change in state law, no increase in property taxes could take place in the school district. Whatever taxing power the school district may exercise in this case will derive from the federal court. The question, therefore, is whether federal courts possess the power to tax or to authorize the collection of a tax. I believe that this is not a power assigned to the judiciary in our system of government. Our cases throughout the history of this court and as recently as last term have reaffirmed that taxation is a power that the judiciary does not possess. There is no support in the Constitution, our history, or our precedents for the statements to the contrary in today's majority opinion. The confinement of taxation to the legislative branches, both in our federal and state governments, was not random. It reflected our ideal that the power of taxation must be under control of those who are taxed. And this truth animates all our colonial and revolutionary history. It is a founding principle of our democracy that there shall be no taxation without representation. The federal judiciary, by design, is not representative or responsive to the people in a political sense. It is independent. Federal judges do not depend on the popular will for their office. And it's not surprising that imposition of taxes by an authority so insulated from public communication or control can lead to deep feelings of frustration, powerlessness, and anger on the part of tax-paying citizens. One of the most troubling aspects of the Court's opinion today is that discussion of the important constitutional issues of judicial authority to tax need never have been undertaken to decide this case. Even were I willing to accept the Court's proposition that a federal court might in some extreme case authorize taxation, this case is not the one. In fact, the taxation power is sought here on behalf of a remedial order unlike any before seen. Instead of using the accepted concept of limited magnet schools, the district court decided to turn the whole district into a magnet, so so that all high schools, all middle schools, and half the elementary schools in the district would be magnet schools offering special programs. Perhaps it is good educational policy to provide a school district with items like those the district court required Kansas City citizens to finance with a judicial tax. For example, a 2,000 square foot planetarium, greenhouses and vivariums, a 25-acre farm with an air-conditioned meeting room for 104 people, a modeled United Nations wired for language translation, broadcast-capable radio and television studios, a temperature-controlled art gallery, movie editing and screening rooms, a 3,500 square foot dust-free diesel mechanics rooms, swimming pools, and numerous other facilities. But these items are part of legitimate political debate over educational policy and spending priorities, not the Constitution's command of racial equality. Perhaps the school district's classical Greek theme school, emphasizing forensics and self-government, will provide exemplary training in participatory democracy. But if today's dicta become law, such lessons will be of little use to students who grow up to become taxpayers in the Kansas City Municipal School District. This case is a stark illustration of the ever-present question whether ends justify means. Few ends are more important than enforcing the guarantee of equal educational opportunity for our nation's children. But rules of taxation that override state political structures, not themselves subject to any constitutional infirmity, raise serious questions of federal authority, questions compounded by the odd posture of a case in which the court assumes the validity of a novel conception of desegregation remedies we never before have approved. The historical record of voluntary compliance with the decree of Brown versus Board of Education is not a proud chapter in our constitutional history, and the judges of the district courts and courts of appeals have been courageous and skillful in implementing its mandate. But courage and skill must be exercised with due regard for the proper and historic role of the courts. I do not acknowledge the troubling departures in today's majority opinion as either necessary or appropriate to ensure full compliance with the Equal Protection Clause and its mandate to eliminate the cause and effects of racial discrimination in the schools. Indeed, while this case happens to arise in the compelling context of school desegregation, the principles involved are not limited to that context. This assertion of judicial power in one of the most sensitive of policy areas, that involving taxation, begins a process that over time could threaten fundamental alteration of the form of government our Constitution embodies. James Madison observed, "Justice is the end of government. It is the end of civil society. It ever has been and ever will be pursued until it be obtained or until liberty be lost in the pursuit." In pursuing the demand of justice for racial equality, I fear the court today loses sight of other basic political liberties guaranteed by our constitutional system, liberties that can coexist with a proper exercise of judicial remedial powers adequate to correct constitutional violations.
I have the opinion of the court to announce in Florida versus Wells. In this case, after the respondent was arrested for driving under the influence, an inventory search of his car turned up a locked suitcase in the trunk. The police officials opened the suitcase and discovered a garbage bag containing a large quantity of marijuana. The Florida Supreme Court held that the marijuana should have been suppressed because of the complete absence of any police policy concerning the way they dealt with closed containers that they found during an inventory search like this. In an opinion filed today, we affirm the ruling of the Florida Supreme Court that the marijuana had to be suppressed. We do not agree with the Florida court's conclusion, however, that to comport with the Fourth Amendment, a policy or procedure governing inventory searches must require that either all containers or no containers be opened. While such policies would be permissible, it would be equally permissible for an inventory search policy to allow police officials to open any containers whose contents they are unable to figure out from looking at the exterior of the container. Justice Brennan has filed an opinion concurring in the judgment of the court in which Justice Marshall joins. Justices Blackmun and Stevens have also filed opinions concurring in the judgment.